founded by the Government of India and FICCI, for organizing this webinar and giving us this opportunity to share our expertise. I am pleased to introduce that in this webinar, we'll be discussing the arbitration landscape in the UAE and India, focusing on navigating commercial conflicts through ADR for Indo-UAE business ventures. We will also look at key arbitration developments in the UAE and the key institutes in the UAE. Considering that we have a large audience with operations both in India and in UAE, we will discuss the enforceability of UAE-seated arbitration awards in India and the emerging trends in the India-UAE arbitration space. To take forward this discussion, we have a stellar panel of legal and financial experts in the field of international arbitration with us to share their practical experience. And just a reminder to all the attendees that we hope for this session to be interactive, and therefore we would request you and welcome questions in the chat box, which we will be happy to address at the end of the seminar. Now, to begin, it's my pleasure to introduce Mr. Arun Chawla. He's the Director General of the Indian Council of Arbitration and the Principal Advisor at FICCI. Mr. Chawla has been instrumental in promoting a robust ADR framework in India. He's a member of the high-level committee constituted by the Ministry of Law and Justice, which is tasked with making India a hub of arbitration. So without further delay, let us welcome Mr. Arun Chawla to open the webinar for us.
Thank you, Nibra. Ladies and gentlemen, very good afternoon and a very warm welcome to our friends from both UAE as well as India who joined this webinar. The topic today is very crucial. I take this opportunity to thank Shardul Amarchand Mangaldas and FICCI Dubai team for partnering with the ICA to organize this very educative webinar. So at the outset, I wish to highlight the long-standing and robust commercial relationship between India and the UAE. I've personally been a witness to it because having spent 23 years with FICCI and superannuated as the Director General of FICCI, which I think Nimra forgot to mention. But I've seen how the relationship has evolved. The two nations have shared a rich history of trade and cultural exchange, and today this relationship continues to flourish with increased business ventures and investments on both the sides, as per the recently signed FTA between the two countries. However, as with any significant commercial engagement, conflicts and disputes are inevitable. It is in this context that alternate dispute resolution mechanisms, particularly institutional ADR, becomes crucial. Ladies and gentlemen, the UAE is the second largest destination for Indian exports and our third largest trading partner in recent years. Being the fourth largest FDI investor in India, the UAE has committed to invest $75 billion in India's infrastructure sector over a period of time. In fact, FICCI recently signed an MOU with Abu Dhabi Investment Authority, the principal sovereign wealth fund of the UAE, and one of the world's largest. It's an anchor investor in the National Infrastructure Investment Fund. Also recently, the UAE Minister of Economy said that India and UAE, CEPA has boosted bilateral trade by 15% in the last 2 years. So, ladies and gentlemen, let me also point out that the World Bank's new Be Ready, Business Ready rankings, which will replace the older Ease of Doing Business rankings, are set to release in the later part of September 2024. And one of the parameters for the ranking system is dispute resolution, which is crucial as it will create a narrative for both our economies. The rankings will rate major economies for assessing the business environment for private sector development. The virtuous cycle for economic development creates a positive relationship between commercial dispute resolution efficacy and investment friendliness perception of an economy. So, for both nations to grow as per their respective standards, it is pertinent to make institutional ADR sacrosanct to commercial disputes. Institutional ADR is increasingly recognized as a valuable tool for managing and resolving disputes in international business ventures, including those between India and the UAE. Now, given the growing economic ties and business interaction between these two countries, institutional ADR offers a structured and efficient mechanism for addressing conflicts that arise in cross-border transactions. Additionally, awards rendered through leading arbitral institutions are generally enforceable under the international treaties such as the New York Convention, which both India and UAE are signatories. But I must say that there are challenges being faced in recognition and enforcement of UAE seat arbitral awards in India and vice versa, thereby defeating the pro-enforcement policy of the convention. So today, in this webinar, we will explore how institutional ADR can serve as a vital tool for managing and mitigating conflicts, fostering smoother business operations, and ultimately supporting long-term success in the ever-evolving business landscape. As India and UAE continue to strengthen the economic relationship, institutional ADR facilitates smoother conflict resolution for joint ventures, trade agreements, and investment projects. So, ladies and gentlemen, without further ado, let us embark on this insightful journey into the world of institutional ADR for Indo-UAE business ventures. And I hope you will find the discussions both informative and inspiring. So a very warm welcome to our speakers and the audience. Thank you very much. Thank you.
Thank you, Mr. Chawla, for laying down the very important backdrop to this discussion of the growing relations between India and UAE and the importance of ADR mechanisms to further the business ties between the two. Now, my next panelist is Ms. Ila Kapoor. Ila is a partner at Shardul Merchant Mangaldas, where she specializes in dispute resolution, where she focuses on domestic and international arbitrations as well as commercial disputes. She's a dual qualified lawyer with rights to practice in India as well as in New York. She has over 20 years of experience across sectors. Has been recognized as a global leader by Who's Legal and Chambers and Partners for the last 2 consecutive years. I welcome Ila and request Ila to take this panel forward.
Thank you, Nimra, and thank you to ICA and FICCI for this panel. Today's discussion is centered around the relations with regard to how disputes work in the investment regime between India and Dubai. And I shall take the opportunity to speak about the Dubai International Financial Center and the Dubai International Arbitration Center, so DIFC and DIAC, and their respective structures and how they approach dispute resolution when between parties that are involved. And then we can see how these institutions foster the development and resort to arbitral mechanisms between India and the UAE. We can talk about how there are developments in Indian institutional arbitration, which should also allow UAE investors, give them some confidence about how disputes will work in India if they choose institutional arbitration. Now, if we begin by talking about the Dubai International Financial Center, DIFC, it is a leading global financial center in the Middle East, Africa, South Asia, the MEASA region. And, it connects the fast-growing markets here through Dubai. Now, it was launched by the UAE by federal law, and it is part of Dubai's strategic vision to diversify its economic resources and to attract capital and investment in this region. It's a financial free zone, which is defined in their laws. It has an independent jurisdiction within the UAE. So DIFC is empowered to create its own legal and regulatory framework for all civil and commercial matters. Now, the DIFC provides for a very robust legal framework for dispute resolution. There are 3 independent bodies which have been established under Dubai law to enable and support the growth of the DIFC. Those is the DIFC Authority, which oversees the strategic development and operation management and planning of the DIFC. This is responsible for development of laws and regulations other than those related to financial services. Then there is the Dubai Financial Services Authority, which is an independent regulator of financial and related services conducted from the center. The DAFC supervises regulated companies and monitors their compliance with applicable laws. And then, most importantly, for the purposes of today's conversation, they are the DIFC courts, which act as an independent administration of justice for resolving all civil and commercial laws. These special courts have been formed in 2004, and they govern the DIFC courts authorities' activities and operations, which are intended to provide greater flexibility and efficacy. Now, how are the DIFC courts structured? The DIFC courts in Dubai, they work through an English common law system. They provide speedy, independent justice in civil and commercial disputes, locally and internationally. Now, it's important to note that only civil and commercial cases are subject to the jurisdiction of the DIFC courts. So if these courts, they don't include criminal law issues that may arise in their jurisdiction. If such an issue arises, then they are sent and forwarded to the proper external authorities. Now, local UAE lawyers, foreign law firms, companies within the DIFC region, these will benefit the most if they include in their contracts, in their agreements, clauses which say that they are subject to the jurisdiction of DIFC courts. The claims and disputes that the DIFC court handles, they can involve enterprises that operate within DIFC laws, any contractual disputes involving the DIFC, parties which may be completely unrelated to the DIFC, but which have included in their contract an agreement by which to be governed by their jurisdiction. So the DIFC courts are part of Dubai court system. However, there are 2 key differences that distinguish them from other Dubai courts. One is, of course, the jurisdiction, and the second is that the law that they adhere to. First, the DIFC courts have only limited authority. We have to keep in mind it's over civil and commercial matters. All other cases involving these issues are handled by Dubai's civil courts. Second, DIFC courts make decisions based on English common law, while the civil courts in Dubai use federal civil procedural law. Now, what is the legal structure of the DIFC? There are 4 different types of courts in the DIFC. First is the court of first instance. This would be a single judge court, and it will be the court where it will decide all commercial matters at first instance. There is a court of appeal, which will be the highest court. Then there is the small claims tribunal. This will be the court that deals with matters which are below a certain threshold or a value. And then there are the international arbitration courts. And this is a key service provided by DIFC courts for firms in this area. These courts use specialized judges. They follow the common law principle. Experts in international arbitration are often appointed as judges from outside of the country, and they will hear matters dealing with arbitration. So we will have cases dealing with applications for interim relief, applications for execution of award, appointment of arbitrators. These will be dealt with by the arbitration courts. Now, DIFC significantly has its own arbitration law, the DIFC arbitration law. This is inspired by the UNCITRAL model law, which is, of course, the global gold standard for commercial arbitration. Now, let's talk a little bit about the Dubai International Arbitration Center, which has existed for far longer than the DIFC. It was established in 1994, and it provides a platform for parties from all nationalities and jurisdictions to settle their commercial disputes outside the judicial courts. Now, initially, it was formed as the Dubai Chamber of Commerce and Industries Commercial Conciliation and Arbitration Center. It has evolved significantly over the years. In 2021, a decree was issued which has granted DIAC independence, it's modernized its governance framework, and it's reinforced its status as a leading center of Dubai's arbitration landscape. Earlier, they had a Dubai LCIA tie-up. Now that has been removed and abolished. So it's consolidated Dubai's arbitral institutions, making it's the sole arbitration center in Dubai. Now, unlike DIFC, which administers disputes using English common law, the DIAC follows UAE arbitration law. DIAC updated their arbitration laws very recently, and they have been modernized, trying to also bring them in line with the UNCITRAL modern law. Core objective of the rule is that DIAC arbitrations are just, fair, impartial, and efficient. By adopting these rules, the parties, the representatives, and the tribunal, they try and conduct the arbitration in accordance with this objective. Some important features of this rule, which make it very progressive, and sometimes even more so than international rules of other institutions like Singapore or London. It's, for example, they have an expedited procedure. So within which arbitrations have to be finished 3 months. This is less than half the time that an expedited procedure under Singapore or London arbitration centers will be completed. They have a concept where a party can apply for interim relief on an ex parte basis. If a party can satisfy a tribunal that it is necessary to get this relief without informing the other party of this application. They also can have a mechanism where you can get ex parte emergency relief. Awards can be signed electronically. We have a lot of waste when a tribunal has to go back to the seat to sign the award. And these rules, do away with that requirement, allowing them to be signed electronically. Of course, it allows for virtual hearings and allows for new procedures for appointing arbitrators. Now, what is the role of DIAC and DIFC in fostering arbitration between India and UAE? As was said earlier by Mr. Chawla, there has been a lot of investment treaties signed between the parties. India is one of the big investors in UAE. We have a lot of investment, trade relationships, and what is needed is to strengthen and enhance our dispute resolution mechanism between these countries to make them more aligned. In this regard, there are 2 countries have signed the Judicial Cooperation Treaty. The idea is to try and bring together and coordinate the 2 systems of enforcement of award and dispute resolution. Now, one of the concerns that Indian investors may have had before the DIFC is that domestic onshore courts in Dubai conduct their proceedings in Arabic. So this means that when documents are moved there, they have to be large volumes of documents have to get translated into Arabic. There is a misconception that it is governed by Sharia law. That is not the case. It is governed by French law, civil law code, which is different. Now, DIFC arbitration, there is a way to combine DIFC and DIAC, which is that you can try and seat your arbitration when you are dealing in Dubai in the DIFC, and you can use the Dubai International Arbitration Center as the institute to govern this dispute. Because as we have said, the DIFC follows a procedure that is more familiar to Indian businesses. They follow English common law, which is what we also follow, which we have traditionally, and we are familiar with it. Our lawyers are familiar with it. It's a financial free zone, and they can make their own civil and commercial laws. It is attached to the government of Dubai, and these laws have been issued by the ruler of Dubai. So the DIFC arbitration law is separate from the one that is followed by DIAC. Now, as I said, it is familiar to Indian investors, to Indian lawyers. It is the closest common law jurisdiction to India outside the SAARC nations. Needless to say, Dubai is much closer to India for resolution of our disputes if we have to physically go there than Singapore or London, both in terms of distance, in terms of time zone. It works more or less within the time zones that we do in India professionally. And that is one of the reasons why there have been attempts. So, for example, the DIAC has signed a strategic collaboration with the Indian with the IAMC, the International Arbitration Mediation Center in Hyderabad. Attempts have been made by both these institutions to form some common conferences, workshops, training programs on international arbitration. Very quickly, attempts in India as well, we have made efforts to improve our institutional arbitration mechanisms. Needless to say, it is a better, we think as arbitration lawyers, that institutional arbitration offers parties a more robust framework. You have a selection of arbitrators, you have appointment procedures which are more clarified, you have scrutiny of awards. So we always encourage institutional arbitration. We have in India many new centers that are opening, the MCIA, as I said, the IAMC, the Delhi International Arbitration Center, and a lot of things that we consider that investors from Dubai may consider bottlenecks for dispute resolution in India are being sought to be addressed in India through the government, through the case law that is being set out, through reports. So recently we have the report, 2024 report of the expert committee to examine the working of arbitration law, and some recommendations have come out which include making arbitral institutions stronger, making them fairer, making them more independent. Just a final statement on these sorts of disputes and the relation between India and UAE. One bottleneck is that UAE is not ratified by India as a New York Convention signatory. So arbitral awards that are passed in the UAE cannot be automatically enforced here under our Arbitration Act. And they have to be enforced through our Civil Procedure Code, through a system whereby the arbitration award has to be converted into a decree in Dubai before it is passed as converted into enforcement in India. Now, the way this is done is if you have an arbitration award seated in DIFC, you would simply go to the court in DIFC and they would recognize this award and they would make it a decree. And after it was made a decree, it would be enforced in India under our Civil Procedure Code 44A. This is still a little bit more complicated than if it was a New York Convention ratified country, where we would automatically enforce it under Part 2 of our Act. So certainly one of the things, given the increase in trade and relations between these two countries, is we need to ratify the UAE and we need to make enforcement of these awards automatic under Part 2. So that's just a little bit about the legal framework of dispute resolution between both these countries. Thank you.
Thank you so much, Hila, for taking us through the two key institutes in Dubai and their jurisdictional parameters, which I'm sure is a very valuable information, particularly for potential investors who are looking at Dubai for investments. Now, our second panelist for today is Dr. Sahita K. Chaturvedi. Dr. Chaturvedi is the Secretary General of the India Business and Professional Council in Dubai and the Head of Finance for Ajmal Perfumes. He has 19 years of experience in finance and management across sectors, including luxury, FMCG, real estate, medicine, and investments. Though he's a chartered accountant, he also holds a doctorate in Islamic finance and a master's in Hindustani classical music, which is a very interesting profile. So we welcome you, sir, and request you to take the discussion forward.
Thank you so much. And my regards to Mr. Arun Chawla and the entire panel, the senior advocates, the legal experts. So I'm not from the law family, but very much from the law fraternity. So that this is what I can say. Thank you, Zohaib, again for connecting the Indian Council of Arbitration and the Indian Council for Business and Profession. So one side the arbitration is ready, other side the professionals and business are also ready, because the business is at the top peak. As Mr. Chawla just announced, that bilateral agreements and the business growth after SEPA. In fact, he is giving credit to SEPA, but at this forum I must say, the time he was heading the Dubai Expo and the SEPA Comprehensive Economic Partnership Agreement was signed a couple of years back. Now in last 1 year time, there is a 30% growth in that. So it was a 65 billion USD, the trade, what we had from UAE and between UAE and India. Now it has reached to 85 billion USD. So it is, and in fact at IBPC level, we are going to celebrate the 2 years of SIPA on the coming 9th of September. Indian Business and Professional Council, we have the focus groups, where one focus group is about the law and the legal matters. I would like to take few of the common challenges what we are facing when the arbitration matter comes in place, because there are many myths, there is a knowledge gap for sure, and if you allow me, I have compiled few of the points in the presentation. So if you allow me to share the screen, I will go for that, or you can share my presentation, what I've shared.
Dr. Saab, please go ahead. Please share the screen.
I think host has disabled the screen sharing. Yeah. So the few of the points as I covered from the perspective of UAE in the 2 days August gathering, and we are used to say that as metaphor that August gathering, but in fact 2 days the August gathering. So in the UAE over the last couple of years, categorically in time of COVID and post to COVID, there has been many changes and many amendments as long as the arbitration is concerned. Presently, the new arbitration law, what the UAE has, it is almost 61 articles, many pages of the changes where the business can take, and the agreement, as it is more of the commercial and the agreement contractual civil areas, but mainly for the commercial purposes. If we bifurcate or classify the common issues between the two, one is procedural, other one is substantive. As we were listening just now, Ms. Ila Kapoor, there is a matter of flexibility, or I can say it is firstly the matter of understanding, that people many of the time are making the mistake that they don't choose in the agreement itself whether it can be an institutional arbitration, or they can opt in institutional arbitration, or they are just open, because they sometimes they are choosing the Dubai as destination in the agreements, but not as the institution of the arbitration. So the flexibility of documents only, or once when they are going oral hearing, the conflict comes, and this becomes an issue. Secondly, the language in the agreement, until they say that it is exclusively the law or the arbitration in case of any conflict, the English language to be used. By default, it goes to Arabic language. Jurisdiction is a matter which was recently discussed, well addressed, and few of the substantive procedural common issues, I would like to mention. One of them is the arbitration agreement. Article 7, which is as like as Article 7 is New York Convention. This also asks the requirements for the arbitration agreement, which allows the exchange of correspondence, whether it is written or not, can be accepted as the evidence. But despite of the soft requirements or writing requirements, arbitration law here in the UAE reconfirm that through Article 4.41, the requirement of arbitration agreement should be signed by person. So one side it is an email or some correspondence, but the other side, the Article 4.1 asks for the signed agreement. So there are the contrary arrangements, and that's where there is an issue can be addressed. Other point is about the time limit for in relation to appointment or the challenge of the arbitrator, but where in one place it is 15 days time, but when we go competence to competence principle of Article 19.2, which gives a 30 days time limit. So there are the contrary problems, or we can say it is a beginning of the answer, beginning of the situations as long as we are moving forward, because the SEPA agreement what we signed 2 years back is almost 1,000 number of tariff are going to be reduced from almost 90% custom duty to the level of 0% custom duty. And that's where the trading arrangements, the commercial arrangements between India and the UAE are going to take place heavily. Investments are as already have started, and that's where these nitty-gritty of the things, that where the calendar limit is there, or the matter of the language or the jurisdiction, the procedural matters will take place. So this time limit of the challenging, signing, giving the information, taking the acknowledgement or the notice period, these are the very beginning of the matter, and certain uncertainties are there, but surely will be by the time we will be overcoming those areas. Language of the arbitration, yes, it is a concern if we are not clear at the beginning. So we at IBPC level to all our members are used to say that please be specific when you are signing the agreements or you are signing, even though you are notarizing, so don't be in the impression that the notary itself is a matter that international parties agreeing that it will be an international language. Arabic, yes, it is an international language, but in context of India and UAE, English is always preferred, and that's where the exclusively we should mention over there, otherwise it is a matter of concern. The technology, as COVID also has brought us all together, as today very frequently we are doing the webinar and the Zoom calls. The law of the country has also accepted to go for the oral hearings. Article 28, Article 33, Article 35, they all emphasize on the use of technology, but the gap of knowledge and the practices is very much there. Many of the times when the email is just sent, and that correspondence, sending the email without any acknowledgement, is accepted as evidence. And that's where our people get in trouble many of the times. So this is a concern of technology, but yes, as long as we are moving forward, the time is teaching us. The beauty of confidentiality remains with arbitration, but again, there is a concern about the confidentiality of the documents. The documents, the evidence which are submitted are not necessarily need to be confidential, because the law of the country allows that to make it public, and sometimes when the cases are very sensitive, where categorically they want to go for confidentiality, and those matters may affect. So again, with the agreement, when we are selecting the arbitration, we are going for arbitration, that matters are also many of the times is heard from our members. Enforceability is definitely a concern, as just before, so I don't want to repeat it again, but how to enforce the decision, arbitration award from India to the UAE or of the UAE. There has been many cases recently when the time was delayed and the civil proceedings took place, and this is a common issue of enforceability when we go for arbitration. Both the countries, whether it is UAE or India, are the countries of rituals, the family businesses, the understanding within the joint family. Many of the times, everything is not written. The communications are prudence over substance. So those differences are there. Language challenge can be addressed by writing, but the cultural differences are the matter where the timeline, that limited timeline, is a constraint, but the knowledge, the expertise, the people who are involved in the tribunal in the arbitration is very imperative to bridge that cultural difference. Is a short summary if for all these concerns what I just mentioned, though these are just highlights from a non-law practitioner, but yes, I am a tax practitioner. But many of the things when commercial law and tax are considered, the company law are practiced by we people. So the firstly we say that adhere to the procedural laws, where as much as comprehensive we can make the agreement and keep the records, wherein specifying the scope, where to seek the arbitration, the governing law, selection of the arbitrator, and ensuring that actions do not violate the public policy in enforcing the jurisdiction. So this is what the summary from my side. Thank you very much.
Thank you, Dr. Chaturvedi, for sharing your insights with us, particularly the common issues that you have seen in your experience, which parties face while conducting arbitrations, particularly the cultural and language barriers. Thank you so much. Now we have our final speaker of the day, who's Dr. Pinky Anand. And we all know she's a eminent legal stalwart and a designated senior advocate in India. He also served as an additional Solicitor General of India from 2014 to 2020, where she represented the government before the Honorable Supreme Court of India. Dr. Anand has a distinguished legal career spanning over 40 years and has represented India in several leading cross-border disputes. She is a renowned expert in private international law and has been called in as door tenant at the prestigious No. 5 Barristers' Chambers in London as well. He is also a recognized arbitrator with leading arbitration institutes all over the world, including CIAC, ICA, DIAC, and DIFC courts, and is also a member of the governing body of ICA. I welcome Dr. Anand and thank you for taking this time out to share your insights with us.
Thank you so much, Nimra, for this elaborate profile that you've got up. I must learn to make it shorter for all of us. But I must say that before I even delve onto the subject, Dr. Chaturvedi's presentation, indeed, Dr. Chaturvedi, delightful. And prior to that, Ela, who's I hope.
Thank you so much, ma'am.
Summarize it. I don't know why you took this issue of not being a lawyer. I think your qualifications are no longer in dispute, if they ever were. So we will leave it at that, but it's been a pleasure because you really crystallized some of the issues that do confront, particularly in this cross-border trade that we have between UAE and India and the conflicts that arise therefrom. So I've seen that a number of the statements have been somewhat crystallized. So let me just kind of run through in a broad way at this point as to what is there which is attracting as far as India and UAE is concerned. And I think Arunji also made it very clear in the beginning when he set the ball rolling as the dynamic Director General of ICA, as he always leads the head-on forward, that basically the trade between the two countries, and so Dr. Chaturvedi also outlined that, has been increasing and booming. The figures are there before us. In view of that, wherever you have ultimately the economy boosting and trade between the two countries boosting, obviously the logical corollary will be arising of disputes and the need then to address these disputes and the manner in which to resolve them. The manner in which to resolve them, of course, from the last almost a decade or more, has shifted away towards ADR. ADR not only as arbitration, but also I believe increasingly towards mediation, because the whole attempt is to resolve commercial disputes which will benefit both parties or multi-parties. Frankly, now with the world across at its feet, we are having multi-party disputes, and I think in that direction, I'll say it now rather than later. India has been very putting its fast step forward. Cox and King's judgment on group of companies, for example, set the way for getting across multiple jurisdictions without necessarily having to implead parties. So that means if the parties are involved, they are not parties to the agreement, even then they can be bound. And indeed, it set the ball rolling towards an international hemisphere that we are looking forward to, aside from a few other things that India has really taken the fast way forward. Between UAE and India, mention of the 8 agreements, the bilateral treaties, the investment treaty, but I think what I found most exciting was the IMEC. So basically the India, Middle East, Europe Economic Corridor and the various memorandum of understandings for these purposes. I think that is another fast way forward. And I've been party to some of the visits and the conferences that have taken part in the system. So you are going to have every possible connectivity across this corridor, which of course also promises to beat other countries at their attempt to have such corridors, and in particular, I might say China, almost shamelessly to say so. But the point being that the countries involved have really involved in this by rail, by ship, by all methods of transportation, and that involves huge economic outflow. It involves huge economic inflow. Trade, work, employment generate activity, and that activity also includes, obviously, within its fold, the legal activities, as I mentioned, and therefore the need for resolution of ADRs. And I can just see the promise of way ahead. I even went to Saudi Arabia in a conference recently. And I mean, the way the prince, for example, is acting in the country there and investing huge funds in the NEON project and the Red Sea project. Indeed, it has been delightful, because the promise is that we all must get involved in generating work, and work for people, which automatically means adding on to the asset situation that we have here. Now, coming back to some of the more technical part of it, the legal part, as Dr. Chaturvedi was saying, even though not being a lawyer. But indeed, I think one of the principal issues that, in fact, Arunji and I were in Dubai about 4 years back, and we were talking about ratification and the notification as far as enforcement of awards from UAE is concerned in India. Now, it is a fact, we have a notification regarding the enforcement of judgments, and Ela was talking about it earlier, and she rightly said, Section 44A, it is possible if DIFC courts, for example, ratify and make it a decree, it will be enforceable. The CPC is, of course, of 1908. So while we have amended our criminal laws, our civil laws are yet to kind of come up to fold. But be that as it may, the notification for enforcement of UAE awards has yet not come into place. And until it does, this is the only method in which we can resolve this issue of enforcement. But we can. It is possible. And I'm sure with the added pressure of trade and the anxiety of all the stakeholders, we hope to see even that ratification come forth. And with the auspices of ICA and other organizations, we are at least promoting it very actively to say, let us do so, because reciprocity is important. But having said that, Dr. Chaturvedi, UAE is very progressive. You don't require such a process. You don't have part 2 of the Arbitration Act. So you have enforcement of a foreign award, whether of DIFC in UAE courts, whether of India in UAE courts. The awards are enforceable, and ultimately all those systems have been set into place. So there's no distinction in that sense between enforcement of a foreign award such as the Indian award. So we have to follow suit, as I mentioned earlier. But thankfully, we can definitely take place forward. So you have one step ahead of us, and we hope to catch up very soon in that respect. Otherwise, there have been, in fact, a number of amendments in the UAE laws, as you mentioned. I don't want to repeat them, but definitely simplifying the way forward. But one of the issues that came up was ultimately the requirement of the arbitrators and the qualifications of the arbitrators. Now, there I just have a suggestion, everybody here. We basically have the definition of a direct relationship, which may disqualify An arbitrator, of course, there is the principle of competence, and the arbitrator can decide that issue. But we do need to possibly consider, if I might suggest that should be defined a little more specifically. Of course, it can be left to a larger story also. For example, in India, we have Section 12 and the fifth schedule, which defines what is meant, at least which is not fully exhaustive, but inclusive of the headings under which you can disqualify, or a disqualification or a challenge to the appointment of an arbitrator may be made. And it is both direct and indirect relationship. But having said that, what I found interesting again about UAE is the fact that initially you had a rule which said that if you were from the arbitral institution, one of the institutions, you couldn't become an arbitrator. And we find that with the growing demand for people who are from the institutions, and as Mr. Chawla and the ICA has rightly headed it, we are encouraging arbitral institutions. We in a big way are. We've recognized, our amendments have brought that into place. We are talking about the Arbitration Council. But as in UAE, has actually diluted now this strict requirement, and subject to certain conditions being fulfilled. Yes, you can be a member of the arbitral institutions, but nonetheless, you may still serve as an arbitrator if you qualify those conditions. So I think again that has been a very welcome step, because you do need qualified and experts and people who got experience in the field, and they would be obviously people who are possibly connected with the arbitral institutions. Off the record, maybe nothing is off the record, but I do think it's very important for also arbitrators. And I say this because, again, I take something from Mr. Chaturvedi's statement. You don't have to be a lawyer or a judge necessarily. What you require is a mix. You need to have multidimensional. But particularly, I would say that arbitration needs its own strengths. So, for example, in India recently, we've had the creation of an arbitration bar of India, which is the first runner on this position. And with that, we've also had various positions where we made the enforceability of foreign awards much easier and the scope limited. I mean, for example, one of the way forwards is NN Global, the interplay in NN Global, the 7-judge bench, which held that if a stamp paper of an agreement was understamped, it was not a defect which was incurable, but a curable defect which could be cured. In fact, right now in arbitrations, we are facing these issues. Now, when should this issue be taken up? When should it be decided? But having said that, don't stall the arbitration on the grounds of something which can be cured. And therefore, this judgment has really not only laid the way forward in technicality, but laid the way forward for a consideration of a speedier arbitration system, which doesn't allow technicalities to come in its way. And to that extent, as I said, UAE has been amazing, because even when there were restrictions, for example, I might cite here the instance of where you require in UAE, there is an issue regarding the signing or the agent or the representative of the party. I believe there was fair strictness in this procedure, but gradually again, it has been diluted. And by and large, I believe UAE courts are now not really allowing this to come as an obstacle to the continuance of the proceeding. And to that extent, again, trying to make it more transparent and more efficient. Similarly, UAE and India have the same kind of broad policy on challenging being restricted to just 2-3 questions. In fact, that is very commendable. Public policy being, of course, the parent one, which goes right from New York Convention to the UNCITRAL, and it stretches across board. From what I have seen of the judgments in UAE, the construction of public policy has been strict. So interference is not the rule by institutions. On the contrary, it is consideration. So I can only mention this at this point to say that we, in all hemispheres, I mean, UAE has come into the picture as far as DIFC is concerned. I am also a member of the DIFC and the DIAC for that matter. I'm qualified to practice there. Ultimately, each of these institutions has been really lending strength. And recent one, which has been again lending big strength, even though this is UAE, is the Saudi Arabian Center for Arbitration. I think it's gone even faster, and their efficiency rate is commendable. But so we all have lessons to learn from each other. And efficiency has to be the rule, because the insistence of ADR in a process is reduce the avenues for challenges, maximize the use of artificial intelligence, which we are utilizing in India. We're sitting across again with systems which are being able to go across board without any difficulty. All the arbitrators, all of us when practicing, increasingly for procedural matters particularly, are utilizing the AI very efficiently. And I believe UAE is also permitting, of course, the artificial intelligence to be used. In substantive hearings, sometimes, or contentious, then we decide to do physical. For example, one matter we were doing virtually all through, we are doing physically tomorrow with Mr. Arun Chawla's institution, the ICA. It is also mine, so I shouldn't only make it his. But that's a choice. But the choice has to be had, and I think COVID times, of course, taught us that virtually can be used very efficiently, and particularly in arbitration. Document-only principle also Dr. Chaturvedi was being talked about. At least as arbitrators, we try to limit. And commercially, I see more and more parties are not that interested in going for evidence, oral evidence, and are happy to go with documents. And we all try to persuade them because really they are not a matter of issue. So why argue? Even our Evidence Act, Dr. Chaturvedi, says if it's a matter of document, you don't need to talk about what the document contains or the contents. It's there. You read it, argue it, say whatever you like about it, unless there is, of course, elements of forgery or fraud or anything like that, which needs to be ultimately proved by way of evidence or supporting evidence or the intention of parties. So, with this in hand and commending ourselves for having gone very many ways forward to progress in the direction of ADR and the institutional structures, we have lessons to learn from each other, and we've learned a few from UAE, definitely, and we hope to learn more. And I hope that we can convey India's commitment to arbitration, not only with the rising of several new international bodies and domestic bodies in arbitration in India, but I must, at the last, put on the shelf mediation. I believe that that really is into being in a big way, because it'll be possibly even faster. And of course, the last on that would be med, which is a hybrid of, and it could be in various forms. And we've used it incidentally in a lot of family litigation, not necessarily arbitration. It's a mix of litigation and arbitration, aside from mediation, arbitration. So I've actually went across board and saw that. And it's decently efficient, doesn't promise necessarily a good outcome, but it ensures that people are able to talk. And I believe ultimately that's what prevails in the last run. So thank you very much, everybody. And thank you, Dr. Chawla, and particularly Dr. Chaturvedi, for your presence. I look forward to Zuhaib. I don't think I was there when he spoke, but thank you so much.
Thank you, Dr. Anand, for sharing your practical insights. Particularly, I think the crux of the issues that we legal practitioners face, I think you've hit all of them, and the significance of mediation, which we all feel is very, very important for faster resolution of disputes. Now, I think we have about 5 to 10 minutes remaining, so I'll quickly move on to the Q&A. We have some questions from our attendees. First one is actually for Dr. Anand, and I think you've partially answered this question as well. But the attendee wants to know how the attitude of judiciary in India has changed, and also in UAE, and any particular key case law that you would like to highlight to emphasize of the change in mindset.
You're right, Ali, when you just said that I had partially answered it. So while we were talking, the two latest trends which have indicated that the Indian judiciary is particularly keen to ensure that arbitration awards are implemented, and I will make a caveat after that, is towards this Cox and King, which is a group of companies doctrine, because it is my belief that you have multi-parties across board. And if you keep across the surface, and with the cyber world getting more and more, and the identities, we saw that in the crypto case, that you didn't even know where anybody is located. So in order to have a binding arrangement which brings in everybody within the fold, because there are multiple layers now, to really unearth those layers is one part. Assuming you've unearthed it, you can't go across the globe chasing everybody at all levels. So this doctrine, I hope, can be adopted, which has been adopted in India by a very great judgment. And in fact, ignoring the earlier judgments of saying no, only parties are bound by the agreement in this world of today. So I think that heralds its own page forward. And the other, which I did mention again, was the interplay, which is the NN Global's Constitution Bench judgment, which deals with the factum that don't allow technicalities to really come in the way of going forward. Let it be substance. and not that. And thirdly, actually, we've had various interpretations in various judgments, and it's been across board, where ultimately on public policy has been limited, as I was speaking about limitation in the UAE. I think India has been doing that. But while we say that, there is sometimes a concern that we shouldn't get so swept away by the fact that you need to be speedy to sacrifice real justice. So to that extent, the DMRC judgment has come in another fashion, in a curative petition, where the award has actually been set aside on the ground that it is patently unreasonable. I leave the House open to consider the impact of these judgments, but generally speaking, yes, increasingly courts are fast. And the commercial courts, incidentally, aside from judgments, I think the coming into being of the Commercial Courts Act itself has proved to be a major leap in this direction.
Thank you. Thank you so much, Dr. Anand. My next question is to Ila Kapoor. So you also had addressed this earlier, but the question is the challenges in enforcement and recognition in India and UAE, both for awards passed in either country. Second is the what needs to be done in such cases. And thirdly, if you can elaborate it with any practical example or any situation that you may have faced.
So actually, I spoke about it, but Dr. Anand spoke about it even more, which is that whereas if you have an award which is seated in UAE and you want to enforce it in India, it's a little bit more cumbersome than the other way around, because UAE is not recognized in India as a ratified state under the New York Convention. So you cannot enforce that award directly. You have to do the circuitous route of going to the court in UAE and getting it converted into a decree, and then bringing it to India to enforce it as a decree from a recognized state. The problem with that is that it's extra layers of legality, extra layers of potential challenges. The other way around is easier, because if you have an award seated in India or actually anywhere outside UAE's jurisdiction, UAE has a simple procedure where you have to bring it in over there. You have to translate it into Arabic. The basics of the UNCITRAL law of challenge is there, and they will enforce it as an award. So it's actually simpler. And the grounds of challenge, again, Dr. Anand spoke about that. We in India maybe use public policy as a broader challenge than it was envisaged originally under the UNCITRAL or under New York Convention countries who enforce this. DIFC and UAE, which are especially DIFC using English common law, will use a much narrower interpretation of that. So we can assume that enforcement is going to be easier going the other way, which is an award seated in India will be enforced in UAE quicker possibly than the other way around.
Thank you. Thank you. The next question is not particularly to any other panelists, but it's on the qualification of arbitrators. So like Dr. Anand mentioned that there is a need for expert arbitrators in specific sectors, and we do see it particularly in construction disputes or in insurance disputes, which can get very technical. So the question is revolved around how do you balance the appointment of an expert versus the expert needing to have some form of legal knowledge. I assume this question is coming from a lawyer, from a sense of frustration that sometimes procedures can be difficult to explain to an expert. So how do you achieve that balance? Dr. Anand, Ila, anybody, Dr. Chaturvedi, anybody who wishes to take this up?
I think Dr. Anand should take it forward.
Let me just get this. The idea is how to meet the challenges, Ali?
So the question is that I think it's coming from a practicing lawyer where, often we have experts who are appointed, but it gets very difficult for lawyers to tell them clearly what is expected out of law and separate that from facts. So having experts, yes, you need it in certain sectors, but the conduct of arbitration in itself, for example, the issues of admissibility, etc., become an issue and become more challenging while communicating with expert arbitrators.
Oh, well, You're right. The point is, frankly, I do see what the practicing lawyer is asking, because when you address, you have two parts of the story. So one, you have the technical part of it, which might be, let's say, the construction, or for example, or the contracts for that matter, and then you have all these legal questions. So there are these two parts to arbitration. But what you normally, when you talk about an expert, you wouldn't have one. You would have ultimately a panel which would include one of the experts. And while I say this, I mean, I would put another domain to it. You actually have increasing practice of having experts who are ultimately putting forth, for example, on damages. And on damages, you ultimately have experts quantifying, and you're actually presenting these versions across to the arbitrators. So that's yet another thing. You have expert arbitrators, which is comparatively rare. You have experts appointed by arbitrators or other the parties. That is become a very regular feature. Now you have regular practitioners in that field who can be identified and actually utilized. Now, of course, there you have two different experts. So then the arbitrators have to choose between those two experts. So yes, the legal acumen required would definitely require, at the minimum, some more than judicial legal skills to understand the implications of the entire transaction.
Thank you, Dr. Anand. I think we're out of time. So I would like to thank all the panelists who've joined us. I think we've covered quite a bit, from the significance of the ADR landscape, given the increasing business relations between the two countries, to discussing the key institutes in UAE which are available for the ADR space, the common issues and challenges, both procedural and substantive, as well as the practical issues of enforceability and the need to consider issues like qualification of arbitrators and other ADR mechanisms such as mediation. I thank all the panelists for their invaluable time and their contributions to this webinar. And I would like Zuhaib to now please share his closing remarks. Thank you.
Thank you, Nimra. Thank you, distinguished guests and all the panelists and speakers here. I get the opportunity, Dr. Anand, little late because I was not the lawyer. I was just coordinating with Sam and ICA back in India. But thank you so much for mentioning me. I would like to take an opportunity to thank you all for joining us today and your active participation in the webinar. It has been a pleasure discussing navigating commercial conflicts, institutional ADR for Indo-UAE business ventures with such an engaged and insightful audience. I would like to extend a special thanks to our speakers for sharing their expertise and valuable insights. Your contributions has been truly enlightening. I would say to audience that if you have any questions or any specific information to be asked on the arbitration, we are here to help you and we are here to answer you. So once again, thank you all for the engagement and look forward for the webinars in future.
I will like to say here, not only just webinars, I think this type of the panel should be live in UAE.
Yes.
Because it is in demand. And this type of experts in with FICCI and in your Connect, I think we should come forward as IBPC to host such an event. So again, with a thanking remark, but a request that let's organize such a panel in Dubai as soon as possible.
Sure,
Thank
Dr.
you, everyone. And we look forward to this physical roundtable sometime in November. I'm sure when the disputes will be there.
Yes.
Yeah.
He will be, of course, amongst us as usual. She's always there to support us. Thank you. Thank you very much.
Thank you so much.
Thank you.
Thank you. Thank you for having us.
Thank you, everyone.
Thank you.